If you are watching this because you or someone close to you has been accused of sexual communication with the child, you are probably frightened, confused, and unsure what happens next. My name is Brian Mason from Liberty Defence. We defend people facing serious sexual offence allegations, including allegations involving online communication, messaging apps, social media, and mobile phones. Sexual communication with a child is a specific offence under Section 15A of the Sexual Offences Act 2003. In broad terms, it can apply where a person aged 18 or over intentionally communicates with the child under 16, where the communication is sexual or intended to encourage a sexual response, and where the communication is for sexual gratification. A common misunderstanding is that there has to be a physical meeting. There does not. The allegation may be based entirely on messages, chat logs, screenshots, social media accounts, phone data, or app conversations. Another important point is the age of consent. In the UK, the age of consent is 16, but that does not mean every case is simple. In sexual communication cases, the detail matters. The police and prosecution will look at the words used, the surrounding context, the age of the person involved, what was known or believed about that age, and whether the communication was genuinely sexual in nature. These cases are often highly technical. They may involve seized phones, deleted messages, multiple accounts, usernames, screenshots, undercover activity, or allegations passed to the police by third parties. Sometimes messages are taken out of context. Sometimes identity is disputed. Sometimes the issue is whether the accused reasonably believed the other person was 16 or over. Sometimes the question is whether the communication was sexual at all. That is why it is dangerous to assume you can simply explain your way out of it without legal advice. If the police contact you, even for what is described as a voluntary interview, you should treat it as serious. A voluntary interview is still a formal police interview. What you say can be used as evidence. Before you answer questions, you need to understand the allegation, the evidence, and the safest way to protect your position. There are also some practical steps you should take straight away. Do not contact the complainant, their family, or anyone connected with them. Do not delete messages, wipe devices, or interfere with accounts. Preserve anything that may help show context, identity, timing, or your understanding of the situation, and get specialist legal advice before speaking to the police. At Liberty Defence, we understand the stigma attached to allegations involving children. We also understand that an allegation is not the same as guilt. Our role is to examine the evidence carefully, protect your rights, prepare you for interview, and build the strongest possible defence from the earliest stage. In some cases, early legal intervention can help shape the direction of the investigation before charge. In every case, it gives you a clearer, calmer understanding of what you are facing and what to do next. If you have been accused of sexual communication with a child, or if the police have contacted you about messages with someone under 16, contact Liberty Defence today. The consultation is confidential, discreet, and non-judgmental. The earlier you get advice, the better protected you are.